Good afternoon, everyone. I am Cyril Joy Obispo from Group 2 and my report is Interrogation. What is interrogation? Interrogation is the skillful questioning of a person who are uncooperative in the conduct of investigation or those who are reluctant to divulge information in his or her possession which are pertinent in the conduct of investigation. In simple terms po, interrogation happens when investigators talk to someone who might know something about a case but doesn't want to tell the truth or share details. So next, basic fundamental rules. The provision of Section 12, Article 3 of the 1987 Constitution and the provision of RA number 7438 have radically changed the procedural requirements for a lawful interrogation of a suspect. Before interrogating a suspect, the investigator should identify himself or herself to the suspect as a law enforcement operation. Siyempre, kailangan po natin introduce yung sarili natin sa suspect na talagang member tayo ng law enforcement organization. Explain to the suspect in general terms the nature of the offense under investigation. The officer should tell the suspect what the investigation is about. Kung anong kaso yung iniimbestigahan na about sa kanya. Inform the suspect of his or her wish to question him or her on matters relating to the offense. The officer tells a suspect that they will asking question related to the case. Like example po, magtatanong kami ng katanungan about sa nakawan nangyari kagabi. Like that. Advise the suspect of his or her rights. Meron siyang limang rights. Right to remain silent. Ito yung hindi niya kailangan sagutin yung kahit anong tanong na tinatanong sa kanya. Right to have a lawyer. The suspect can have a lawyer present during questioning. Right to a free lawyer. If he or she cannot afford one, the government will provide one if needed. That anything said may be used in court. Anything the suspect says can be used as evidence. Number 5, do you understand your right as I have explained to you? The officer must confirm that the suspect fully understands their right. 6, ask if the suspect still wants to give a free and voluntary statement. Finally, the officer must ask if the suspect is still willing to talk, knowing their rights. Next po is procedures in interrogation. The suspect may choose to remain silent. Ito nga po yung may right siya na hindi sagutin yung mga tanong na tinatanong sa kanya ng officer. The suspect may request a legal counsel. Ito yung meron siyang karapatan na magkaroon ng abogado during the questioning. The suspect may waive his or her rights. Ito po yung pwede niyang i-give up yung rights niya at aminin na lang yung na nagawa niya yon. Matters not affected by the rules. This means there are certain situations where the usual rules about giving Miranda warning rights of the suspect do not apply, but only if the statement or action are voluntary and not forced by the police. First po is yung confession without warning. The court said that not all confession without warning are invalid. Some are still valid if they are given freely. A. Any statement given freely and voluntarily is of course admissible as evidence. If a person gives a statement freely and willingly without any pressure or threat, it can be accepted as evidence. B. There is no requirement that the police stop a person who enters the station and state that he or she wishes to confess a crime. Dito naman po, police are not required to stop someone who comes to the station voluntarily. Ito po yung kusang pumunta yung suspect sa police station para umamin sa krimen na nagawa niya. C. Similarly, there is no requirement to stop a person who calls the police to offer a confession. Parang bilang po, pero ito, on telephone lang siya na pag-amin. Hindi siya yung personal na pag-amin. D. Volunteered statement of any kind are not barred by the Constitution and other statutes and their admissibility is not affected by the statutes. Voluntary statement or any kind given without force, threat, or promises are valid and can be used in court because they are not against the Constitution. Number 2 po is during field investigation. This means the police are allowed to gather evidence at the crime scene or outside the station even if someone is already suspected as long as it's not a formal custodial interrogation. A. Inquiry of person not under restraint. Dito po, police can talk to people freely if they are not under arrest or being forced to stay. Example po, asking bystander what they saw at the scene. B. General on the scene questioning. Ito po yung mga police can ask question at the crime scene to know what happened. Ito yung ano yung nakita nila, sino huli nilang nakitang kasama ng victim, sino yung tatingin nila gumawa neto, like that. C. Other general questioning of other person in the fact-finding process. Ito naman po, police can ask anyone questions to find facts and evidence while investigating. In short, when police are still investigating in the field and no one is under arrest, they can ask questions freely without needing to give Miranda warning. Next po, terminologies in interrogation. Witness, a person other than suspect who gives information. Ito po pwede siya yung victim or yung expert na nag-aano sa crime scene. Suspect naman po, a person considered on reasonable grounds to possibly be guilty. Ito po yung sinasuspect na gumawa ng crime. Subject, the person being interrogated, whether it's witness or a suspect. Purpose of interrogation. The primary purpose of interrogation is to obtain information which will further the investigation. 1. To obtain information of innocent or guilt. The goal is to find out whether the person being questioned is involved in the crime or not. 2. To obtain confession from the guilty. Ito naman, if the suspect is truly guilty, interrogation aims to make them admit their crime voluntarily. 3. To induce admission. Ito naman po, to make the suspect admit small details connected to the crime even if they don't fully confess yet. 4. To learn facts and circumstances. To understand how the crime happened, when, where, how, and why. 5. To know where evidence is. To find out where the suspect hide any tools, stolen items, or weapon used in the crime. 6. To know accomplices. To identify other people involved in committing the crime. 7. To find result of the crime. To know what happened because of the crime, such as injuries, damage, or stolen property. 8. To develop additional information. To get new clues or leads that can help continue the investigation. 9. To discover other crimes. Sometimes, interrogation can reveal other crimes committed by the suspect or their group. Next, qualification of an interrogator. Knowledge and interest. A good interrogator must be smart, observant, and curious. They should have wide knowledge about people and situation to understand motives and behavior. 2. Alertness. An interrogator must always be watchful and attentive. They should notice every detail, spot contradictions, and adjust their question when needed. 3. Perseverance. Interrogation takes patience and persistence. Some suspects are uncooperative or can't remember detail, so the interrogator must keep calm and continue carefully. 4. Integrity. The interrogator must be honest and trustworthy. If the suspect doesn't trust them, they won't cooperate. The interrogator should never lie or make promises they can keep. 5. Ability in observation and interpretation. The interrogator must be able to read people, their words, facial expression, and body language, and understand what those reactions means. 6. Logical mind. The interrogator must be organized and clear thinking. questions should follow a logical order to find facts that prove or disprove the crime. 7. Playing the part. Sometimes the interrogator may need to act showing sympathy, anger, or understanding depending on the situation. But they must stay in control and not let emotions take over. Lastly, power of self-control. The interrogator must stay calm and professional at all times. Losing temper or control can ruin the interrogation and make mistakes happen. Thank you po.